Well, listen to this. A Florida chemist now accused of tampering with police evidence. And now at least 2,600 cases may have to be reopened as a result. This started when investigators discovered prescription pain pills missing from the state crime lab evidence locker. Some had actually been replaced, we're told, with over-the-counter pills. Now, the suspect is currently not working. Not clear whether or not that is temporary. Criminal defense attorney Holly Hughes joins us now. Holly, thank you for coming in. I appreciate it.
Sure, Poppy. Good to see you. And Don Lemon looks like he's having way too much fun out there.
How did he get that assignment? Guys, management?
You, we're inside.
What? I know. All good things come to those who wait. Don, having a great time. I'm going to join him after the game. But listen to this. When you talk about this, the magnitude, 2,600 cases that this chemist was in one way, shape, or form involved with in the state of Florida in all different counties. How do you begin investigating this? Do you bring in someone from the outside, an independent party?
Well, what they're doing is policing themselves, essentially, because it wasn't the entire lab that was accused of being the problem. It was this one specific chemist. And when you talk about that huge number of 2,600 cases, they're not all going to be suspect because a lot of those were probably pleas. And when you enter into a plea agreement with the state, you are waiving your right to a trial. You're waiving your right to an appeal. So not all of those will be called into question.
Do you think that they're going to bring in someone from the outside? And in terms of knowing if one of these might be one of your cases, how do you find that out? When and how are you notified in a situation like this?
Well, in any case that involves drugs, they are tested in the lab, and the lab report must be turned over to the defense attorney. So every defense attorney will have a lab report with a name on it, and they will know if this chemist, who is now suspected of tampering with evidence, had hands on their evidence. And they are the ones who will go back and say, based on this, we want a do-over.
But don't you think everyone that was found guilty would want a do-over? And just talk about the complexity of that process.
Well, there's a couple things the court will look at. If it is found that there was tampering, and that's a high standard, how are you going to prove that?
Right.
Because each individual sample might not have been replaced. And what he was doing was taking the real drugs and replacing them with over-the-counter, which would be helpful to some defendants. I mean, if you test it and it comes back as NyQuil, who cares? That's not illegal. Right. So what you're looking at is anybody whose evidence was tested by him, they are going to want to challenge that and have it retested if the sample was not used up. And when they make that appeal, the court is going to look at what we call error. And is it harmless error? Was there so much overwhelming evidence to prove guilt that this lab test was not the only thing that proved it? So they may look at your case and say, yeah, there was error, but it was harmless in light of all the other evidence, and you do not get a do-over.
Yeah, we will see. Holly Hughes, appreciate the legal insight on this. What we know is ahead, reams and reams and reams of paper and court filings and a lot of busy lawyers, that's for sure. Thanks, appreciate it.
Thanks,
all right,
Poppy.
more to come from Super Bowl Boulevard. Don Lemon,